Albertson and Davidson. In this video, I'm going to walk you through how to prepare a notice of hearing. So if you have a case in probate court, a trust case, a will case, almost every single case is going to require a notice of hearing once the court sets a hearing date. So let's go through what a notice of hearing looks like and how you can fill one in. So the first thing I do is I actually just go to Google and I just type in Judicial Council forms. And the California Judicial Council actually has a whole bunch of forms that you can use in a lot of different types of lawsuits. So we're going to select the category and we're going to go down here to probate and decedents estates. And this is where you're going to find all the forms for not just estates like probates, but also for trust matters. And we'll go ahead and see the forms. Now, I already know that we want form DE-120. But if I didn't know that, you could search for a form by name or by number. But I know what form we want. It's form DE-120. And here it is in a enlarged format. And what this is this is a form that you use, a document that you actually fill out and then mail out to all the related parties in your lawsuit in order to notify them of when a court hearing has been set by the court. And the person who files the document with the court is the person who's responsible for notifying everybody else about the court hearing that was assigned by the court. So we start off at the top and we're just going to type in our name. If you were doing this and you're representing yourself, you would just put your own name in here, but I'm going to use mine. And then I'm going to put in my law firm information. So if you're a lawyer, you'll do that. If you're not, then you'll just put in your own address. And then I'm going to use the address that I'm at a lot of the time, Salk Avenue in Carlsbad. We have 5 different offices in California. I spend a lot of my time in San Diego County. And then you want to make sure you include your telephone number. You want the court and the other parties to be able to get a hold of you if they need to do so. Fax number, if you have one, you can put in a fax. It's optional. Email is also optional, but you really should put one in because there's times when the court might want to get a hold of you and they will use email from time to time. And then you're going to put here who you're the attorney for. Now, if you're not an attorney and you're just appearing on your own behalf, you can put, oops, my typing skills, per. That just means you're representing yourself. The other thing you could do is just put in your own name. So my name's Keith Davidson and I'm an attorney for Keith Davidson. Everybody will understand what that means. But I'm an attorney, so I'm going to put in the name of my client, Bob Smith. And then you're going to put in the county. So let's put in Los Angeles County. It's the largest county in California. We have a lot of cases there, although we're in a lot of different counties. So whatever county you're in, San Diego, Santa Clara, San Mateo, Orange County, you just type it in there. And then you have to put the street address. And the first one is the address where the court is physically located. Or, and on the mailing address, you have to put in the court's mailing address. Now, in this case, they're the same, but sometimes they're not. And so if they're not, then you'll put in the proper addresses. And then here you'll put the city and the zip code. I don't remember the zip code for Los Angeles, but you can look it up and you'll put it right there. And then you put the branch name. So this is the Central Courthouse. If you don't know the branch name of the court you're dealing with, you can look it up on the website. And if you can't find one, you can just leave that blank. Now down here, you're going to check a box, and it's going to depend on whether you're doing an estate, like a probate estate, or you're going to do anything else. So a trust matter, a conservatorship matter, a guardianship matter, you're going to check this box because that's all called in the matter of. And then you'll type in what the matter is. So let's say we're doing a trust action. We'll say the Bob Smith Trust. That's the matter. If this was a conservatorship action, we'd say in the matter of, and then we type in the conservatorship of, and then whoever the name of the person is. So you can use this very widely for just about any other type of case that's not a probate. And then down here, you're going to click the box as to whether it's a decedent, meaning a probate estate, a trust, or everything else. So if it's not a probate estate or a trust, just click other. In this case, we're doing a trust action, so we're going to click trust. Next, you're going to want to put in your case number so the court knows where to file this once they receive it. And I just made up that number, but whatever your case number is, just put it in there. And now this is the part where we really get started in earnest. So number one, notice is given that, and this is the party who filed the document that requires a hearing. So in our case, Bob Smith is the one giving notice. And representative capacity, if he were a trustee, I would type that in there. If he's not, if he's just a regular Joe and he's just appearing on his own behalf, then leave it blank. And then you have to type in what you filed. So maybe we did a petition for instructions or a petition for trust contest. Whatever it is we did, just type that in here. And that way people will understand what it is you're giving them notice about. And then on number 3, this is where we're going to give the details of the hearing. The court will give you the hearing date, and you're going to type it in here. So November 1, 2018. Let's say it's 8:30 a.m. Oops, my typing skills again. A.m. Department, make sure you put the department. If there's a room number, you'll put that. If it's not a room number, in most courts don't have a room number, you just leave that blank. And then you have to tell the parties where the address of the court is, where the hearing is going to be held. Most of the time, you're just going to check shown above, which means this address up here, that's where the hearing is going to be held. If the hearing is going to be held somewhere else other than the addresses up here, then you'll check this box and you'll specify the address. Just type it in. Most of the time, you're just going to click shown above. So that takes care of the first page of our notice of hearing. So we're in good shape so far. So now we're going to go down to the second page. You'll see that the form automatically fills in the name of the matter and the case number. So we're good there. You're going to skip over this clerk certificate of posting because you're not ever going to do that. Instead, you're going to go to the proof of service by mail. You're going to have to mail this out. And yet this is the whole purpose of this form is to prove that you mailed it out because you're going to sign this under penalty of perjury, which means that if you say something in here that isn't true, or if you don't do something that's stated in here, then there could be criminal consequences for having perjured yourself. So we got to make sure we fill this out right. So number 2, my residence or business address this is the place where you're conducting the lawsuit out of. If you're just doing it on your own, you can just put your home address or you can put your work address. That's fine. It doesn't matter. Either one will work. People just want to know where they can get a hold of you. So I'm going to put my business address. And then we have 2 options. You can either deposit the sealed envelope with the United States Postal Service, meaning you're the one who actually puts it into the post box, or you can place it into your mailing system at an office. So some big companies or big law firms have mailing departments. And so even though I'm the one filling out this form, I may not be the one who's actually going down to the post office and putting the mail into the post box. In which case I'm going to click B, which is I'm placing it into the mail system that our office has. I'm familiar with that system, and I know that that system typically requires that anything I put into that mail system is going to be mailed within the ordinary course of business the same day in a sealed envelope with postage fully prepaid. So you have to know that that's what your system does if you're going to check this box. Otherwise, just check A if you're the one taking it down, putting it in the mailbox, and you'll be fine. You have to put the date it's mailed. Everybody wants to know what day it was mailed, so we'll put October 1st, 2018. And again, with my typing skills, there we go. And then we're going to say where it was mailed. So where exactly did you put this into the mail system? So that's right here. Number 5 is kind of interesting. So number 5 says that not only did you mail this notice of hearing that we're preparing now, but you also sent with it all of the documents referred to in this notice. And by that, they mean all the documents up here under number 1. And so it's very good practice, in our opinion, to do that. So when you serve a notice of hearing, also send copies of everything you listed up here in number 1. And that way you won't have any problems. Nobody can say, well, I didn't get the documents or something like that, because you have proof that I put the notice of hearing into a sealed envelope along with all of these other documents. And so I know that they received them, or they should have received them. And then you're going to put the date that you actually signed this form. And it doesn't have to be the same day that you mailed it. Some people say that it really should be, the next day, because that way it's already mailed. But usually you're going to see that it's dated the same day. And then you're going to type in your name here, and when you print it out, you're going to sign it over here. And again, you're signing this under penalty of perjury, so if you're saying that you deposited it into the mail on October 1 in Carlsbad, California, that's got to be right, so make sure you do that. And then you're going to put the name and address of every person who received this mailing. If you have 4 or fewer people, you can put their name and addresses right here on the form. If you have more than that, you can use an attachment. Typically what we do is we'll check the attachment box, and then up here we'll actually type see attachment, just so everybody is aware that there's an attachment and nobody thinks that we filed a notice of hearing that's blank. And even if I have 4 or fewer people on my notice attachment, I still will use an attachment, because that way I can keep the name and addresses of the parties and the lawyers on a separate piece of paper, a separate Word document, and I can use that on all of my filings. So sometimes I have to attach a proof of service to something other than a notice of hearing, and I've got that notice list already set up, ready to go. And so here, rather than typing everything in, a lot of times we'll just use an attachment. So that means I have to actually attach that separate piece of paper to this notice of hearing, and I have to mail it out. Now, once you're done, you sign this, you mail out everything to everybody. You also have to file this form with the court, and that's why at the top here, it looks like something you would file in court. So after mailing it, you have to take it to the court. The court will stamp it over here in this clear area, and it'll go into the court file. And then when you show up to your hearing, the judge is going to look for this, because they want to make sure that everybody receives proper notice before the hearing can commence, because the hearing can't take place without notice. And if the judge looks in the file and doesn't see this notice of hearing in the file, then your hearing is going to get continued, because the judge is going to say, I can't hear this matter today because you didn't give proper notice and file proof of giving proper notice with the court. So it's not good enough to actually fill out this form and do all of this stuff. You have to file this notice of hearing with the court too. And then down here you can save the form, you can print the form, and then once you have it saved, you can use it over and over again. This is a form that you're going to use a lot in your case, because anytime there's a hearing set, you have to mail one of these out. And anytime a hearing is continued, it's very good practice to mail it out as well. In court, you might hear the attorney say, we waive notice, which means that the next hearing can be set and you're not required to send out this form, this notice of hearing. But it's still a good idea to do it anyway. There's really no downside to giving people notice of a hearing. There's only upside, which is, hey, I was just careful, I was being conservative, and I made sure that everybody knew about this hearing. So that's how you prepare and file a notice of hearing in your probate court action.